A compromise agreement is a legally binding contract when and if it is signed up by all parties. That's the employee, the legal advisor and the employer. Up until that point, it's negotiated on a without prejudice basis. It's all part of a negotiating process to reach a settlement between an employer and employee, and it's a full and final settlement if it's signed up. So even if an employee feels he has a complaint against an employer, or in actual fact has already made a complaint to the tribunal, for example, that has to be withdrawn if he signs up to the compromise agreement. As I say, it's a legally binding contract with full contractual force. It needs to cover certain statutory requirements to make it a valid agreement, which is part of the reason you need to see an independent legal advisor to make sure all this is on board, because if any of those requirements are absent, it invalidates the document. Employers generally find compromise agreements extremely effective and an attractive way of dealing with matters, because even with their best endeavours, if they have dismissed an employee or terminated a contract of employment, there's always the concern that maybe they've done something not quite the way they should have, and will that employee potentially make a complaint against them? Because any employee who has been dismissed has 3 months less 1 day to make a complaint to a tribunal if he feels he's been treated unfairly, for example. So if an employer follows due process, at the end of it, if he offers a compromise agreement to the employee and it's signed up by the employee and the legal advisor, that is the final clean break. It removes that 3 months less 1 day and that potential worry, are you going to have a complaint against you? Because if a complaint is made to the tribunal and it's accepted, you have to answer that. So now you're involved in litigation, which can be extremely expensive very quickly. So a compromise agreement puts that all to rest. And another attractive aspect of that particular document that employers find very welcoming is that they can deal with these things very, very quickly. If they need to make serious, drastic cuts in their business for whatever reason, they can offer compromise agreements almost immediately. And it saves the time and expense of going through due process to satisfy the fairness of the procedure requirement, which they potentially could fall down on. So it's fast and effective, and in the short term and long term, it's very cost effective. In the absence of the new statutory disciplinary and grievance procedures which are being drafted by government, it's recommended that employers follow the ACAS code regarding disciplinary and grievance procedures. What employers must always bear in mind is that they are fully entitled to protect their business, and the Employment Rights Act exists just as much for their benefit as for the employees. Most employers that I take instruction from seem to fear the Employment Rights Act and think it's an exercise in trying to destroy them. It's not. It doesn't exist for that purpose. So if you are having difficulties with any of your employees for whatever reason, you're certainly permitted to challenge and deal with that. You are fully entitled to dismiss any employee, provided you've satisfied the legislation. If an employee, for example, is not performing to your requirements, that could potentially fall under the head of one of the permitted for reasons of dismissal of capability or even conduct. But you must follow and be seen to follow due process to make the whole process fair and transparent. And if you do that, there are no grounds for a complaint. What I always say to my employer clients is that basically the only reason an employee can make a complaint against you is that you've given grounds to. So if you follow due process and adhere to it, you protect yourself. There's a tremendous reluctance to instruct solicitors without something sort of at their door, so to speak. They don't want to spend money at expense like that, which is understandable. They're running businesses. We understand it. I understand that. But Having solidly, soundly based contracts of employment in place is a complete exercise for employers in protecting themselves, because you can close so many doors, so to speak, before they're even opened, without a complaint being landed on your door from some employee, either current or past, that they can still be employees and make a complaint against you. For example, if you haven't provided that Section 1 statement, which you're obliged to, that's a complaint to the Employment Tribunal if your employee so wish. And you can be fined between 2 and 4 weeks' wages per employee, which can be considerable amounts of money very quickly. Contracts of employment are not necessarily very expensive documents to have drafted by me. If an employer comes to instruct me for a contract, prices can start from as little as £250. Now, how and if those costs and increase is subject to what instructions the employer would give me. Obviously, if they want a highly sophisticated contract drawn up with lots of specialised clauses and so forth, that will increase the cost of it, sometimes considerably. But we try and be conscious of it and advise the employers appropriately and give them our best estimate from a very early stage. What employers need to be completely aware of is that the employment legislation as it exists is constantly being tested in the courts. Each decision, an employment tribunal and an employment appeals tribunal, and in particular the Court of Appeal, once they make a decision as to their interpretation as a particular piece of legislation, of course we have to adhere to that, but it can fundamentally change our understanding of what the legal position is. We need to constantly be aware of this, and this changes, without exaggerating, almost on a weekly basis. So advice that I would give to particular employees regarding a particular situation or matter or particular statute is always subject to these decisions. And employers, it would be wrong if they were, so to speak, rest easy because they have an understanding of the position or they have appropriate documents in place for their employees, because they're always subject to change, and this is something that they need to be completely aware of.